Welcome back to the deep dive. Today we are staring down a legal abyss.
That's a good way to put it.
We're talking about intellectual property. The entire framework that's supposed to govern creativity and ownership and value. But specifically, how that system, which is centuries old, is trying to deal with generative AI.
And it's not just grappling. It's failing.
It seems like more than just a rough patch or a legal headache. What we're analyzing today it's a structural breakdown, isn't it?
It is. It's a crisis of coherence. I mean, the whole traditional IP framework, it's built on these really fundamental ideas. Human authorship,
Right.
fixed, stable works, direct copying, all of that. And it's not just that it's insufficient for regulating AI. The argument we're diving into today, it says that using these old IP doctrines for large language models is actually logically impossible.
Logically impossible. That's a huge claim.
It is, because the technological reality of how AI works just completely invalidates the core legal assumptions we've been using for hundreds of years.
So this isn't about tweaking a few rules here and there. This is about needing a whole new legal operating system.
That's it, exactly.
Our mission today, then, is to unpack this comprehensive new legal blueprint. It's being called the five-theory paradigm for AI IP. We're going to look at the defense of this paradigm against its critics, and then we'll get into the actual governance blueprint, the policy tools, the new institutions that would be required to make this work.
And for you, the listener, this is really a shortcut. It's a way to understand the conceptual necessity behind what's probably going to be the future of AI regulation.
So what's the core of it? What's the central philosophical pivot here?
I think it's that we have to stop looking at AI through the lens of human creativity. And AI doesn't create a work in the copyright sense. It doesn't make a fixed thing.
It's doing math.
It's doing math, exactly.
Yeah.
It generates probabilistic events. These things emerge from what's called latent geometry and parameter ensembles. So if the law is trying to regulate changes from a fixed book to a statistical probability, a geometric structure, then the law has to change its focus.
Or it just collapses.
It collapses under its own inconsistency, yeah.
Okay, let's unpack this geometry and probability problem. If the old IP system is crashing, what are the five new theories designed to replace it? The ones that are supposed to map onto how AI actually works, just give us the acronyms, and then we can break them down.
Right. So these five emergent theories, they're meant to be the new operating system for AI property rights. They are PCR, that's probabilistic composition rights.
Okay.
LSR, which is for latent space rights. CPR, constitutive parameter rights. Then there's NAT, that's non-linear attribution theory.
Yeah.
And finally, SCR, for synaptic cultural rights.
And each one governs a specific part of the AI process that's, not human.
That is non-human and mathematical. It's about where the value is actually created in the machine.
Okay, so let's start in the disaster zone. The foundational failure of classical IP. It's built on these pillars: authorship, originality, fixation, copying, and substantial similarity. The argument here is that LLMs just shatter all five at once.
They absolutely do. I mean, take authorship. IP law requires a human creative spark, right? The sweat of the brow, independent conception.
Someone had to make it.
Someone had to make it.
Yeah.
An LLM, though, yes, it's trained on human data, but it's just executing algorithms. Its output is stochastic, it's random, statistically derived. Even if a human writes a brilliant prompt, the final choice of a word, that last token, that's a mathematical event. It's governed by probability, not human intent.
And what about fixation? That's like the most basic element of copyright. You have to fix your work in a tangible medium, a script, a saved image file, something.
Right, but the real asset here, the thing of value in the AI, the latent geometry or the parameter array, that's not a fixed work. It's this constantly evolving high-dimensional mathematical space.
A map of concepts.
A map of concepts, exactly. And the output itself is generated on demand. It's an event. Even if you save it, that saved file is just one possible outcome from this underlying probabilistic engine. When a human copies a book, the copy is static. It's identical.
Yeah.
When an AI generates a poem, it's a momentary projection from a dynamic system.
So the very prerequisites for copyright protection just aren't there. But what about the enforcement side, like the legal doctrines of copying and substantial similarity?
And this is where you hit the real conceptual deadlock. The law has to prove that the AI copied the original work.
Yeah.
But the AI isn't reading a text file and reproducing it.
No?
It's converting the text into vectors, into numbers. It's learning the mathematical relationships between concepts, and then it reconstructs new patterns based on those relationships. Asking if an output is a copy of the training text is, Well, it's like asking if a baker copied the wheat field when they made a loaf of bread.
That's a great analogy. It's a transformation, not a reproduction.
It's a transformation.
Hmm.
And that distinction is essential. It means our legal language just doesn't accurately describe the technical process.
So the tools we use in court, like the substantial similarity test, they just don't work.
They completely fail. That test requires you to compare two static things, but the output is stochastic. If I give an LLM the exact same prompt twice, I might get two slightly different outputs.
Right.
Which one do I compare to the original copyrighted book?
Right.
The process is non-deterministic. The law needs a static target, and AI gives it a dynamic, constantly moving one.
Okay, so copyright is in trouble. Let's broaden this out. You mentioned patent and trade secret also collapse. Why can't a company protect its model as a trade secret, like the Coca-Cola formula?
Well, for a trade secret to work, the information has to give you an economic advantage by being kept secret. And while a company can keep its parameter weights private, the whole point of the model, the way it makes money, is by generating public-facing output, articles, images, code, music. The moment the model interacts with the public, the core asset that creates the value is being revealed through what it can do. The secret isn't staying secret.
So if the thing that makes you money is inherently public-facing and random, trade secret law is sort of an empty shell.
It's an ineffective shell.
And patent, why can't we just patent an AI's invention?
Because patents are based on these clear steps, specific claims. A human inventor follows a process. They have to reduce it to practice. And while an AI can come up with new drug candidates or chemical compounds, the AI itself isn't inventing in a legally recognized way. It's not intentional. It's not following a step-by-step process that a patent examiner can verify.
So we're back to the authorship and inventorship problem.
We are, and it's made even worse by the fact that it's almost impossible to define the exact inventive claim within a 70 billion parameter network. Where's the invention?
Which is why the sources are calling the current legal situation improvised law. Courts are just trying to hammer these square AI pegs into round IP holes.
And what's so fascinating is that you can see the plaintiffs and the judges struggling to even talk about their complaints using the old words. You look at the current cases. In Getty v. Stability AI, the issue isn't really about one-to-one copying of an image.
Right, it's about style extraction.
Style extraction. Getty is arguing that the AI learned the Getty aesthetic, specific color palettes, the compositions, the patterns in their photos, and now it can generate new images in that style.
And under traditional copyright law, that's a losing argument. Style isn't protected.
Exactly. It's unequivocal. Style is not protected expression. And yet, the economic harm from having your entire aesthetic signature wholesale absorbed and then reused is massive. The language they're using, style extraction, cultural pattern theft. We're seeing this in cases like Anderson v. Stability AI too. It just proves the old doctrines are not enough.
They're improvising.
They are improvising legal language to describe realities like latent space, like probabilistic generation, that IP was never ever designed to regulate. We need a system that gets that the value is being extracted mathematically, not expressively.
Okay, so the need for a new system is pretty clear. But changing something as fundamental as IP law is, well, it's politically and academically a huge lift.
A massive lift.
And the authors of this framework, they spend a lot of time on a structured defense, right? They tackle the 5 most predictable academic objections head on. For you, the listener, I think it's important to understand not just the solution, but why sticking with the old rules is, well, why it's just not an option.
Absolutely. You have to show both conceptual necessity and that it's feasible to implement. So let's start with the big philosophical attack.
Yeah.
The one that says the law can just choose to ignore how the technology works.
Objection number 1, the naturalistic fallacy, or the is doesn't equal ought argument. The critics are saying, look, just because the tech is probabilistic and distributed, the law is not obligated to copy that reality. We can keep our human-centric concepts if we want. We can assert human priority over the machine's reality.
It's a powerful, very standard philosophical attack in legal theory. But the rebuttal is, I think, devastatingly simple. And it's this concept of ontological coherence.
Okay, break that down for us. Ontological coherence.
Right. So the law isn't technologically determined. It doesn't have to slavishly follow technology. But it must track the ontology, the underlying nature of the thing it's governing, when that ontology is what determines liability and value.
What happens when it doesn't? When the law and the reality are out of sync?
The law becomes functionally useless. It creates injustice. Think about property law. It tracks the physical reality of land boundaries, right? If the underlying facts change, if wealth suddenly isn't about land anymore, but something else, then the legal categories built for land just collapse. For 200 years, the core economic ontology of IP was that value came from fixed expression.
A book, a song.
Exactly. Now, the core economic ontology is that value comes from the mathematical transformation of data into latent geometry.
So if the law keeps trying to regulate the fixed expression, which isn't where the value is anymore, and it ignores the latent geometry where all the value is, it's basically failing to regulate the market. That's the coherence failure.
Precisely. This isn't just a philosophical preference, it's recognizing what the new reality is. And we've done this before. When the internet came along, courts couldn't apply physical trespass rules to websites. They had to invent new legal categories, like domain names as property, or new ideas about privacy, like metadata. Same thing with biotechnology. They had to create new rules for DNA sequences. Those shifts weren't about bowing down to technology. They were about achieving coherence between the legal rules and the economic reality. If creation is now machine transformation of geometry, then the law has to regulate geometry.
That feels like a very strong answer to the philosophical objection. But let's move to the practical one, the one that I think feels more challenging in a courtroom. Objection number 2, enforceability. The attack is simple. Law needs standards that a judge can actually administer. How can judges possibly understand 70 billion parameter models? Judges cannot litigate vectors.
Yeah, this objection assumes that courts only deal with simple things, which is just laughably false.
Right.
History completely disproves this idea that it's impossible. Courts already adjudicate incredibly technical, complex subjects. Well, think about a high-stakes chemical patent dispute. Judges routinely have to get their heads around and rule on the complexity of Markush structures. These are highly complex, non-intuitive families of chemical compounds. Or think about biotech cases involving CRISPR-Cas9 edits and the tiny nuances of engineered DNA sequences.
And they don't do it alone, right? They have expert witnesses who translate all of that complexity.
Exactly. The complexity is managed institutionally. A court doesn't need to understand how all 70 billion parameters work individually. What it needs are legally cognizable evidence formats. It needs tools to turn that complexity into forensic facts that can be used in a trial.
And the framework proposes some of these tools.
It does. It proposes several specific tools designed for exactly this. For example, instead of a work, you'd have probabilistic generative units, or PGUs. This would be the new unit of comparison, defining a specific, measurable pathway of generation.
A pathway.
Yeah, and then you have latent trajectory signatures, which are essentially a traceable map of how the AI navigated its internal knowledge map to produce an output. It's like a GPS track for the generation process. And, of course, parameter fingerprinting, which creates a definitive auditable ID for the model's core engine.
So instead of a judge saying, I can't understand the math, they're presented with a verified parameter fingerprint and a latent trajectory signature that proves, forensically, that Model X used a proprietary part of Model Y's internal map.
That's the goal. You convert the scientific reality into a legal fact. And the institutional analogy makes this totally feasible, just like courts rely on forensic accountants to unpack complex financial crimes.
Or biomedical engineers in patent cases.
Exactly. This new system would require a new class of specialized professionals. We'd need AI auditors and forensic model examiners, people trained and certified to validate these fingerprints and reconstruct these trajectories. The impossibility argument only works if we refuse to adapt our institutional support system.
That's a powerful rebuttal. Okay, let's group the next 2 objections together. Radicalism and abstraction. The argument that this is all just too drastic a change.
Right. The charge of radicalism. It's an unavoidable consequence of necessity. History shows that every single time a new asset class emerges, software, the internet, DNA sequencing, the new legal structure, looks radical to the people in charge of the old one.
I remember when people argued software couldn't be copyrighted because it was too functional.
Exactly. Software was too abstract, too functional. DNA was a natural product that couldn't be patented, but necessity won out. Courts will always prefer conceptual necessity, a doctrine that actually works over doctrinal comfort, which is an existing doctrine that's collapsing. Since authorship and substantial similarity are already failing in court, well, radicalism is just another word for recognizing the new status quo.
And what about the abstraction objection? That ideas like latent manifolds are just too mathematical, too theoretical for law.
Well, the counterpoint is pretty direct. AI architecture is inherently abstract. A correct legal theory has to address that abstraction. Otherwise, the law is regulating a ghost.
So how do you make it concrete?
You operationalize it through the governance blueprint. Just like the abstract idea of a reasonable expectation of privacy is made concrete with rules about warrants and data collection, the abstract idea of latent geometry is made concrete through things like latent zone licensing and vector difference standards. Abstraction is just the philosophical starting point. It's not a flaw.
Nice.
You use familiar legal tools, licensing, registration, auditing, and you just apply them to a new abstract object.
Okay, that covers 4. The last one is redundancy. Why can't we just modify what we already have? Tweak fair use or trade secret law to cover AI's unique needs?
Because the failure is structural, not incremental. Modifying fair use only really deals with the input stage of the training data. It doesn't help you with the creation of the underlying asset, the model itself. If the fundamental requirement for copyright human authorship is gone, no amount of fair use tweaking can save it.
The foundation is cracked.
The foundation is gone. And if the asset is a probabilistic, public-facing geometry, trade secret law is impossible to enforce. The collapse is at the root of each doctrine. That makes redundancy impossible. You need a sui generis regime, something built from the ground up, specifically for geometric knowledge.
All right. We've established the necessity, we've batted away the skeptics, now we have to move from the theory to the reality. If these 5 emergent theories are the foundation, this next part is the policy blueprint, the actual tools and institutions needed to implement them.
Exactly. This is where we align the law with AI's technical reality. And the goal is twofold. One, you have to protect the actual structural AI assets, the latent zones, the parameter arrays. And 2, you have to do it in a way that prevents big tech from creating monopolies over these essential new assets. You need a transparent, predictable market that fosters competition.
Okay, let's start with the most abstract but maybe the most valuable asset, the knowledge structure itself. Theory 1, Latent Space Rights, LSR, managed through Latent Space Governance, LSG. What exactly is being protected here?
LSR protects the geometric and topological knowledge structures, the latent manifolds, the clusters. Think of latent space as this complex, multidimensional map of all human knowledge that the AI has learned.
So it plots cat and kitten close together.
And cat and automobile very far apart. Exactly. That geometric structure is the economic value. Copyright fails because geometry is not expressive text. LSR is designed to govern this non-expressive computational structure.
And the blueprint proposes classifying this geometric space into 3 layers for licensing. This seems key to preventing that monopoly you mentioned.
It's essential. This is the 3-layer structure. Layer 1 is the public latent zones, PLZ. These are the parts of the map derived exclusively from public domain data. Wikipedia, Project Gutenberg, open source image databases. This is classified as shared cultural geometry.
So nobody can own it.
No exclusive ownership is allowed. This ensures that the foundational building blocks of our culture remain accessible to everyone to build on.
Okay, so an AI model trained only on public domain stuff is operating entirely in the PLZ. But what about the big commercial models that mix in licensed data?
That's layer 2. The semi-public zones, SPZ. These are trained on mixed or licensed corporate data from Getty Images, academic journals, news archives. This zone is governed by some really sophisticated tiered licensing mechanisms.
Like what?
Things like usage-based royalties, where a model pays a tiny fee every time its generation process draws heavily from an SPZ asset. And crucially, model-to-model access licenses.
Model-to-model access. That sounds complex. What does that mean in practice?
It means Company A, which owns a specialized financial model, and SPZ can license Company B to run queries directly against that specialized geometry, without Company B ever physically copying the data or the parameters. You're leasing access to a specific knowledge topology.
So the proprietary knowledge can be monetized without being stolen.
Precisely. And requires mandatory latent zone audit logs to track all those model-to-model interactions for billing and compliance.
And then the highest tier, for super proprietary data.
That's layer 3. The proprietary latent zones, PRZ. These are built from very specific, sensitive, proprietary data. Maybe a pharma company's 10 years of internal research data or a bank's private client communication archive. These zones get exclusive LSR protection. The owner can control access completely and demand latent path access audits to make sure no unauthorized models have been using that specific expensive geometry.
Okay, that makes sense. So that's the map. Now for theory 2. Constitutive parameter rights, CPR, and parameter rights management, PRM. If LSR is the map, I guess CPR is the engine that drives through the map.
That's a perfect way to put it. CPR protects the guts of the model. The internal structure, the weight matrices, the parameter clusters. This is the core competitive advantage. It's how the model learned to prioritize certain pieces of information over others.
But how do you regulate something that's basically just billions of numbers?
You create a definitive identity for it. And the key policy tool here is the Parameter Fingerprint Registry, PFR. The idea is that any model above a certain size, say 10 billion parameters, has to submit a cryptographically hashed fingerprint of its parameter arrays to a central registry.
A model DNA registry.
It's a model DNA registry, exactly. And this fingerprint lets an official auditor determine if a model has been improperly cloned or illegally distilled from another.
So this really moves IP away from protecting the final output and toward protecting the underlying technical architecture as a tradable asset.
And that leads right into the market tools, like the parameter licensing system. This is so important for competition. It would allow for model-to-model parameter leasing or even partial parameter franchising.
So you could license out just one really good component, like a great coding module inside your bigger model.
Exactly. You could also license distillation rights, which would allow a smaller, faster model to legally learn the skills of a massive proprietary model for a fee. This is designed to prevent big tech from just monopolizing all the essential knowledge that gets embedded in their core parameters.
All right, theory-free. Probabilistic composition rights, PCR. This is about the generative act itself. If the first two theories protected the foundation, this one protects the process.
Right. PCR protects the generative pathways, the statistical events. It replaces the old focus on the fixed output. The investment a company makes is in the architecture that creates the probability distribution. So that's what needs protection.
So if I ask an AI to write a story in the style of Edgar Allan Poe, we're not regulating the final story. We're regulating the unique recipe the model uses to assemble the words.
That's it, precisely. And this requires a fundamental shift in how we measure infringement. We need something called the trajectory-based attribution standard. TAS. So infringement assessment moves away from comparing the static surface text, which can often be just a coincidence, to comparing the pathways. The legal question becomes, did the generation process follow a trajectory that significantly overlapped with a proprietary latent zone, a PRZ or a licensed SPZ?
And how would that translate into actual compensation for the rights holder?
Through an output-derived royalty matrix. If that trajectory analysis shows the generated output relied heavily on proprietary assets, say it drew 80% of its key concepts from a licensed medical database, that specific output event triggers a calculated micro-royalty obligation back to the owner of that licensed latent space.
So a direct financial link between usage and compensation.
A direct link. Something traditional copyright really struggles with when it comes to these random outputs.
Okay, now we get to the biggest headache for lawyers. Who is responsible when the AI messes up? Theory 4, Non-linear Attribution theory, NNATs.
This sounds like it's all about distributed liability. It's designed to solve the black box causation crisis. When an AI hallucinates defamation or generates something harmful, traditional causation, A cause B, it fails because the process is distributed across billions of parameters and it's not intentional.
So what does NAT replace it with?
It replaces that impossible linear causation with something called influence distribution.
How do you quantify influence in a legal setting? That sounds really difficult.
You use specific tools like influence graphs and sensitivity-based responsibility curves. An influence graph would map the relative causal contribution of different factors.
Like what?
Like the user's prompt, do they specifically ask for something illegal? The model's core parameter topology, is there an inherent bias in its architecture? And the training data source was the bias embedded in the data it learned from.
Okay, let's run through a quick example. A user asks a model for biographical info, and the model hallucinates something defamatory about a real person. Lawsuit happens. How does NAT handle that?
Under the old system, you'd just sue the developer. Under NAT, a court wouldn't just blame one party. The NAF, the framework, would allocate multi-actor liability. The influence graph might show the user's prompt was totally neutral, but it might also show the model's internal pathway had a high parameter sensitivity toward generating false outputs about that specific person.
Maybe because of a tiny biased section of the training data.
Exactly. In that case, the liability would be weighted more heavily toward the model developer or maybe the data provider who created that bias. It's the only way to assign responsibility in a system that's truly distributed.
Okay, finally, theory 5. Synaptic cultural rights, SCR. This sounds like the answer for artists who feel like their unique styles are being stolen.
It's designed to govern the extraction and recomposition of style vectors, artistic signatures, cultural manifolds, all that stuff. It recognizes that while an individual style isn't protectable under copyright, the systematic wholesale extraction of professional patterns is a real economic loss that needs to be governed.
But if style is unprotected, what is SCR actually protecting?
It's protecting the pattern of transformation. It would allow artists and cultural groups to register their style vectors and symbolic pattern fingerprints in a cultural pattern registry.
A style vector.
Think of it as a measurable summary of an artist's signature elements, their specific palette usage, their brushstroke density, compositional symmetry, things a machine can quantify. If an LLM then uses this registered pattern, SCR would require the model to disclose the similarity weight and log the pattern influence when it generates an output.
So it creates transparency.
It creates transparency, and it opens the door for compensation. So if a pop artist has a distinct visual style, they register that pattern. If an AI service then offers a feature to generate images in the style of artist X, that would trigger a compensation mechanism under SCR.
So it changes the question from, did you copy a fixed image, to
Did you license the use of a proprietary cultural pattern for commercial gain? It's a whole different economic transaction.
this entire framework, though, it sounds like it demands a massive institutional overhaul. These new ideas don't just slot into the current Copyright Office.
No, not at all. They require dedicated new bodies. The framework proposes two key ones. First, an Algorithmic Rights Commission, or ARC. This would have to be a politically independent specialized body.
What's its job?
The ARC would be the main regulator, like the FCC is for radio spectrum or the Patent Office is for inventions. Its job would be to classify the latent zones, the PLZs, SPZs, PRZs, maintain the parameter fingerprint registry, conduct trajectory investigations in disputes, and issue rules on parameter licensing. It's the administrative infrastructure for the whole new regime.
And what about the people needed to run the technical side of things?
That's the second piece, the creation of the AI model auditor profession, or AI-MAME. These are the forensic experts. They'd need to be certified professionals, just like patent examiners or forensic accountants.
And they would be the ones validating fingerprints, reconstructing latent trajectories.
Exactly. And providing expert testimony to the ARC or in courts.
Yeah.
The whole feasibility of this new IP law really hinges on creating this professional class.
Okay, this is where we put the 5 theories to the ultimate test. Because the real measure of a new legal paradigm is whether it can solve actual disputes, predictably and justly. Let's look at 4 hypothetical but probably inevitable future court rulings using the language of this new framework.
Right, and what the mock jurisprudence in the sources shows is how the law would shift the actual conceptual language used in the courtroom. You'd move away from words like copying and toward phrases like geometric transformation and probabilistic event.
So let's start with Case A, a future version of NYTV OpenAI, let's say in 2026. The current issue is whether using copyrighted text to train an LLM is infringing reproduction. Under current law, it's just this intractable fair use fight.
But if we apply the new paradigm, the predicted holding is that the claim fails under traditional copyright law. The court would make a clear distinction between copying and transformation. It would rule that training is the transformation of text into latent geometry. That's a functional process, not the reproduction of expression.
So copyright doesn't even apply?
Copyright does not govern latent space.
Mm-hmm.
LSR, Latent Space Rights, does. So the court is essentially saying, you filed your complaint under the wrong law, your grievance might be valid, but it's about the violation of a geometric structure, not textual reproduction.
The significance of that is huge. It's a judicial recognition that latent manifolds are computational transformations, not copyrighted works. It just changes the whole legal battlefield.
Completely. The input is no longer the target, the transformation process is.
Okay, Case B, a future Getty v. Stability AI in 2027, the style extraction battle. Is learning a specific aesthetic unlawful?
Under today's copyright law, the claim fails because style isn't protected. But under the new paradigm, the court would recognize that what Stability AI is doing is learning style patterns as probabilistic clusters. And that falls directly under SCR, Synaptic Cultural Rights.
So what would the ruling be? Would they find infringement under SCR?
The predictive holdings suggest the court would dismiss the current copyright claim, but in doing so, it would state that the only viable path forward for a claim like this would be under a future SCR regime. The court would rule that while the activity is not copyright infringement, it does constitute the extraction of cultural pattern vectors.
So it defines the harm even before the law to fix it is fully implemented.
Exactly. It points the way.
Mm.
It says only a future cultural pattern registry would allow Getty to claim royalties for pattern reuse.
Okay, KC Gima v. OpenAI, maybe in 2028. This deals with the output. When an LLM generates text or music that's statistically very similar to a copyrighted song or book.
This is where PCR, probabilistic composition rights, gets tested. And the predictive holding is that similarity in the output, even if it's identical, generated through probabilistic reconstruction, does not constitute copying.
Wow.
The court would focus on the unit of analysis. The relevant unit is the underlying probabilistic composition unit, the PCU, the generative event, not the surface text.
So even if the output looks identical, if the trajectory signature shows the generation was a novel statistical event, there's no infringement.
Correct. The court declares the output is an event, not a work. No violation occurs unless the generation pathway, the PCU, improperly overlaps with a proprietary latent zone defined under LSR. That would be a PCR violation, a breach of compositional rights, but not a copyright violation. That's the crucial conceptual leap.
Finally, Case D, a criminal liability case around 2031. This is the high-stakes one. Harmful AI hallucination, like generating instructions for a crime or severe defamation, the ultimate black box crisis.
And this is the test for NAT, non-linear attribution theory. Traditional liability fails here because you can't trace a linear cause. The court's holding, driven by NAT, would state that liability is proportional to the influence distribution across all the actors, human and machine. It would use the influence graphs and the parameter sensitivity reports from the AI auditors to determine shared responsibility.
Can you give us a concrete example of how that liability curve would work in a criminal case?
Sure. Imagine an AI generates detailed instructions for building a weapon, and it's used in a crime. If the AIMI audit shows the user's prompt was vague, but the model's underlying training data had been heavily weighted toward harmful weapon blueprints, a flaw in the parameter design, the influence curve would put more responsibility on the developer for that pathway sensitivity.
And if the user was the one pushing for it.
Right. If, conversely, the user deliberately refined their prompt over and over again to specifically extract that dangerous output, their influence score would rise dramatically, and that would lead to a much higher personal liability. It's the first real adoption of a multi-actor influence curve to assign responsibility in a system where there's no single cause.
It seems like what these cases show is that the existing court system is already in this conceptual vacuum. They're trying to find language for these problems that just doesn't exist in the current laws.
And the 5 theories provide that necessary language. They bridge the technical gap and could lead to administrable, predictable rules.
So wrapping up, what is the big takeaway for our listener here?
The takeaway has to be the philosophical demand for ontological coherence. The law has to reflect the true nature of the thing it governs. LLMs generate distributions, they generate manifolds, influence pathways. And to keep forcing these phenomena into legal boxes designed for 18th century printing presses, well, it guarantees incoherence and market chaos.
Which makes it clear that this can't just be a modification of copyright. It has to be a sui generis regime, a whole new legal species designed for geometric knowledge and probabilistic inference.
It has to be a system that integrates all 5 elements. LSR for the knowledge geometry, CPR for the parameter ensembles, PCR for the generative pathways, NAT for the distributed liability, and SCR for cultural patterns. You have to regulate the asset where the economic value is actually being created.
So what's the transition path? How do we get from where we are now, this collapsing structure, to this new coherent system?
The sources outline a pretty clear trajectory. We're already in phase 1, recognition. You see judges acknowledging latent space and parameter-based arguments in court right now. Next, we'll move into phase 2, hybridization, where courts start mixing old copyright law with new tools, like maybe mandating trajectory analysis in high-stakes cases.
And the final phase.
Phase 3, full sui generis emergence. That's the formal adoption of the parameter fingerprint registry, latent zone licensing, likely driven by national or global regulatory bodies like that proposed ARC.
And what does this all mean for us? I mean, we are entering an era where the dominant creative agent is non-human, the expressive form is not fixed, and the economic asset is non-expressive geometry.
It forces us to confront the deepest question in property law. If creativity becomes collective, iterative, and largely machine-driven, what is the moral and institutional basis for property rights at all? The future of creativity, I think, depends entirely on recognizing that AI doesn't just challenge IP, it requires us to reinvent it wholesale. The question isn't if the law will adopt the language of latent geometry, but when it will formalize it to keep pace.
The ultimate challenge here is realizing that the tools we use to regulate books and paintings are just. They're useless for regulating the knowledge architecture of the future. The next phase of IP won't be about protecting what you can see, it'll be about protecting the mathematical structure that allows you to create it in the first place. We'll leave you with that provocative thought. Are we ready for a legal system where property rights are measured in vectors and probability curves? Think about that the next time you use an AI tool.